The assumption or rejection of a contract is typically done via a motion, and that has to go before the judge, and all other affected parties have to have an opportunity to chime in, to object to whatever's going on, because if a contract is being assumed, well, that might adversely affect some other entity, or if it's being rejected, it might adversely affect some other entity. So we have to do this by motion. We go before the judge. And if the judge is convinced, after considering all arguments in favor of and against the proposed action, then the judge will grant the motion. Now, if the contract is being rejected, then, of course, the entity that was the non-debtor participant to the contract will be in a position of perhaps being damaged. And so that entity will be able to file something called a proof of claim in the case, saying, because of this contract rejection, I was damaged in this amount. I'd like to be paid through the plan. Typically, that kind of claim is what's called a general unsecured claim. To remind any listeners what an unsecured claim is, it's best to start with what a secured claim is. A secured claim is a claim that's secured by a tangible asset. If you don't make the payments, the creditor can take the asset back. So an unsecured claim is a claim where there isn't something that can be repossessed in the event of a default. So that sort of claim will be an unsecured claim. Now, in some contexts, that unsecured claim can be given better treatment than other unsecured claims. In other words, it can be classified as a certain type of priority claim. Maybe as a little side note here, you might think, well, debts are debts in bankruptcy. That's not entirely true. It turns out that not all debts are treated the same. We've already mentioned what are secured debts as opposed to unsecured debts. Secured debts have special treatment because the creditor, of course, has special rights attached to the collateral securing the debt. Within the realm of unsecured debts, Congress, in its extremely finite wisdom, has seen fit to give certain special creditors better treatment than others. Those are called priority unsecured claims. And even within the realm of priority unsecured claims, there are different levels. If you want to plumb that, you can take a look at Section 507A of the Bankruptcy Code. Another one of those sort of long-winded sections that take a little parsing. I will say the Section 365 that I've mentioned a couple of times, that is this section dealing with executory contracts and unexpired leases, is a real mess. It, I think, embodies Otto von Bismarck's comment that there are two things that the population should never see being made, and they are sausage and legislation. And Section 365 appears to have been cobbled together by making certain special interests happy. And there are portions of that section that are not entirely internally consistent. In any event, so if you're going to reject a contract, you may end up having to pay that creditor whatever percentage that creditor's class is. Remember, I said the unsecured debts are put into priority classes. If that's a general unsecured creditor, it's probably not going to get a whole lot. But if it's a priority creditor, it might get paid, in some cases, in full. And then the acceptance of or assumption of the lease, that's a little bit different. If you were already current on the lease, there was no default, then typically you're just going to pick up where you left off and there won't be any change in the terms. On the other hand, if there has been a default, then it does depend on the kind of lease or the kind of contract as to how that's taken care of. But typically you're going to have to cure whatever the default is promptly, typically right away, and give what's called adequate protection, adequate assurance that you're going to be able to continue making those lease payments or contract payments fulfill the obligations associated with the assumed contract as time goes on. And once again, as I've said several times, it does have to be approved by the judge.